Hello friends, in the series on the income tax cases, today we will discuss a case which is based on a revision application filed by the assessee before the commissioner under section 264. As all we know that whenever a negative order or an assessment order is passed creating some demand, the assessee has two options. He can file the appeal before the CIT appeal, which is a lengthy procedure. The other is that he can file a revision application against the order before the commissioner under section 264, but the demerit in filing the revision application before commissioner under section 264 is that there is no appeal against that order. The issue before the Honorable Bombay High Court in the present case was that if the assessee was non-compliant during the assessment proceedings, so whether on this ground the revision application of the assessee can be rejected. This issue has been taken up by Honorable Bombay High Court in the case of Ramesh Madhukar Dole versus Principal Commissioner of Income Tax and others in a writ petition. This case is reported in 483 ITR at page number 802 and the date of the judgment is 18th November 2024. In the present case, first of all, the assessee filed his return of income in a wrong form. Later on, the assessee realized that he has chosen a wrong form, so he corrected the form by filing a revised return, and the assessee claimed section 54 exemption. The assessee has sold some tenancy rights, due to which the assessee has incurred some long-term capital gain, for which the assessee claimed exemption under section 54F by purchasing a flat. When the assessing officer during the assessment proceedings inquired about this section 54 exemption, then the assessee could not reply to the assessee and the assessing officer was forced to pass the assessment order under section 144, that is best judgment assessment. In the present case, the assessee chose not to go to the CIT appeal and the assessee filed the revision application before the commissioner under section 264 and the assessee produced all the evidentiary evidences before the commissioner for proving his claim under section 54F. In the present case, it was very clear that the commissioner was very much with the assessee and was convinced with the claim of the assessee under section 54F. But the learned commissioner rejected the application of the assessee under section 264 solely on the ground that the revision application cannot be entertained because the assessee was non-compliant during the assessment proceedings. Now, since the assessee cannot file the appeal against this order, so the assessee filed the writ petition in the Bombay High Court against the rejection of revision application under section 264, and when the Honorable Court heard the matter, the court said that in the present case, the commissioner should not have rejected the revision application as non-maintainable simply because of the reason that the assessee was non-compliant during the assessment proceedings. The court said that it was the duty of the commissioner to take the revision application to its logical conclusion. The court said that in the present case, the commissioner has declined the revision application on the wrong presumption of law that if the assessee has not complied during the assessment proceedings, so the revision application should be rejected. The court said that in the present case, the commissioner has erroneously concluded that revision is not maintainable. So the court remanded the matter back to the commissioner to reconsider the revision application of the assessee on merits and appreciate all the evidences filed by the assessee in claiming the exemption for section 54F. Friends, this is the classical case that the authorities just wash their hands from accepting the application of the assessees, whether it is section 154 application or whether it is section 264 revision application, by simply giving one or the other reasons which are not maintainable under the Income Tax Act. The court directed the commissioner to appreciate the evidences filed by the assessee and to entertain the revision application on merits. At the end of this video, once again, I am repeating the name of the case. The name of the case is Ramesh Madhukar Dole versus Principal Commissioner of Income Tax, and this case is reported in 483 ITR at page number 802, and the matter has been decided by Honorable Bombay High Court on 18th November 2024. Thank you, friends.